Hello everyone, welcome to the Hindu. In a major blow to CM Siddaramaiah, the Lokayukta in Mysuru has filed an FIR against the CM, his wife, and two others on Friday, September 27th, following orders from a special court for people's representatives in Bengaluru. The move comes close on the heels of the Karnataka High Court verdict on September 24th, which upheld the governor's action of granting permission to conduct an inquiry against the CM on the allegation of illegalities in allotment of 14 MUDA sites to his wife, Parvathi. This was in response to CM Siddaramaiah's petition challenging the legality of the governor's August 16th order granting approval for investigation under Section 17A of the Prevention of Corruption Act 1988. In the midst of all these legal developments, Siddaramaiah also finds himself in the grip of a political crisis with the opposition's growing demand for his resignation. Joining us for a conversation today on the High Court's verdict and the possible future course of action that the embattled CM will take is the Hindu Karnataka's legal correspondent and senior deputy editor, Krishnaprasad. Hi, sir. Welcome to the show. Let us begin with the HC's verdict itself. So how did the High Court go about the case?
Thank you, Nalmi. See, actually, the High Court has dealt this case, Chief Minister Siddaramaiah's case, in two parts mainly. One is completely a legal issue on the powers of the governor, whether the manner in which the governor has acted upon on the complaint and granted permission for investigation. And another part is totally on the facts of the case, that is allegations and its contents. So High Court has dealt these issues in separate and in depth.
Okay. So what has the High Court said on the question of law?
It's actually very, very toughly fought legal issues by the advocates who represented Siddaramaiah. So actually, one of the main allegation against governor made on behalf of Siddaramaiah by his advocates were that he should not have acted against the aid and advice given by the state cabinet, which had requested him not to entertain the complaint, which had sought for permission for investigation under the Prevention of Corruption Act, Section 17A. But another argument made on behalf of the CM was that governor was acted politically. So these are the two main arguments. Apart from that, there were another argument which was made that governor did not apply his mind, saying that he did not consider the complaint at all. He had simply granted sanction without discussing the merits of the case. These are the three main points on which the Siddaramaiah's counsels had argued. The High Court had gone each of the allegations one by one and said on the first issue of the cabinet advice to the governor, saying that don't take action, don't grant approval for investigation. So here High Court said that governor in this case, particularly in this case, when the allegations is against the chief minister under whom the entire cabinet functions, he need not go by the advice given by the cabinet, which directly works under him. Here, argument on behalf of Siddaramaiah was that he did not participate in the cabinet meeting. But the court said he may not have participated in the cabinet meeting, but it is he who has authorized the Deputy Chief Minister, D.K. Shivkumar, to chair that particular cabinet meeting, which only discussed about the letter of the governor in which he had sought the Chief Minister's response on the complaints who wanted to have permission for investigation against him. So court said that the governor was well within his power under the constitution and as per the interpretation of the law done by the Supreme Courts in various cases, that here the cabinet's advice itself can be construed as biased because it was actually on the directions of the chief minister, though not directly, but indirectly. So it says that cabinet was met on the direction issued by the chief minister, though he has not participated in the meeting. And moreover, it is he who has asked the chief secretary to send the response to the governor's notice issued to the chief minister, and which was placed before the cabinet. And court also noted that both the chief minister's response on his personal capacity as well as the response sent by the cabinet in the form of advice requesting the governor to reject the complainant's request for grant of approval for investigation. So both these responses were the one and the same. In fact, it is verbatim. That's precisely what has been argued on behalf of the governor. It is merely a copy paste of both these responses. And when the aid and advice was on behalf of the chief minister, there was no need for the governor to go by that particular advice, which is in a way directly biased, because the court says that no cabinet which is appointed by on the recommendation made by the chief minister will be able to give an advice to the governor which is independent or it is unbiased. So all the members of the cabinet were none other than the ministers appointed on the aid and advice of the chief minister to the governor. So governor in this kind of a case need not go by the aid and advice of the cabinet, which otherwise in all other cases, in majority of the cases, he has to follow. But here, when the allegation is against the chief minister, under whom the cabinet comes, despite his absence in the particular meeting, governor has every right to exercise his discretion and take an independent decision to whether to grant permission for investigation against chief minister or not. So court has very clearly held that governor's action is perfectly as per the law and as per the law interpreted by the Supreme Court. Another aspect of law that is discussed by the High Court was on the argument on behalf of the chief minister that non-application of mind by the governor. The argument was that governor did not apply his mind. He has not cited proper reason in his order of August 16 and 17, in which he has granted permission for investigation against chief minister. Court says, though that particular order does not discuss in detail about the allegations against chief minister, but the files maintained in the governor's office about this case, governor has dealt the issue in depth. And court says that Supreme Court has said that governor in such cases need not discuss every details of the case or the allegations in his approval, in his order of granting approval for investigation. And whatever he has maintained in the file and his conclusion, it matches very well. So governor, it is not just that you cannot say that governor has not only, not acted against the non-application of mind. In fact, the court said governor has, applied his mind in abundance. That is more than what is required. So governor acted in such a way.
Okay.
Yeah.
What were the observations of the court, with respect to the allegations and the facts of the case? You said that's the second part of the...
Before going to the facts of the case, there's one more issue on which the governor, the chief minister has argued that here the governor could not have granted permission without seeking a report from the police officer under section 17A of the PC Act. So here court said that there is no need for the competent authority, where in this case is a governor, to seek an report of the allegation before granting sanction. Court said the governor was perfectly followed the law as per the section 17A of the Prevention of Corruption Act is concerned. So there is no illegality on this issue also. In fact, the court has framed so many issues on this legal issue and answered in favor of the decision taken by the governor. So court did not find anything against the governor. And regarding the second question on the facts,
Yeah.
Actually, it is on these facts are culled out from the allegations made in the complaint. This is about that 14 sites, land sites allotted to Chief Minister's wife, Miss Parvathi, by the Mysuru Urban Development Authority, MUDA, in Mysuru, in lieu of the so-called 3-acre 16 guntas of land, which was used illegally by MUDA to form layout. So, to compensate that, MUDA has claimed that it had allotted 14 sites in a very upscale area of Mysuru, though the land was acquired much about 15 to 20 kilometers away from the Mysuru city. So, the allegation against the Chief Minister by the complainants before the special court, before the governor, and also during the argument before the High Court were that in 1992, the MUDA had notified certain areas for acquisition for Bengaluru layout in Mysuru, the third stage Bengaluru layout, Mysuru. And in 1997, the MUDA had passed a final notification acquiring certain parcels of land, including this 3-acre 16 guntas of land, which is a contention issue in this case, which actually the Chief Minister's wife got through a gift deed. What court says is that in 1997 and 98, 99, 3 crucial developments took place in this case. In 1997, the MUDA had acquired the land, issued final notification. And in 1998, MUDA had passed an award, that is, announced compensation, and that compensation came to be deposited in favor of the then landowners of this 3 acres, 16 guntas of land.
Okay.
Though this compensation was deposited in the court, the original landowners, one by Ninga, he had not come before the court or the MUDA to take that compensation. He had not responded to the notice. So court said, and the third thing is that in 1998, on request made by one Devaraju, who is one of the sons of Ninga, who was the original landowner, had filed an application before MUDA to denotify this land. That is, to delete this land, 3 acres, 16 guntas, from denotification. So court noted that, and MUDA in 1998 has accepted this to denotify the application for denotify this land, and government in 1998 also approved this denotification. In 1999, MUDA and government approves for denotification, 98-99. But despite this, MUDA had gone ahead and formed layout on this parcel of 3 acres, 16 guntas of land.
Okay.
And what happened? This Ninga was not there by the time. He had died.
Okay.
So, Siddaramaiah, and during this period, Siddaramaiah was the Deputy Chief Minister in the government of Karnataka. And court says that this process of denotification itself is illegal because the person who had the Devaraju, court says that person who had no right to over the land had asked for denotification of this land. Okay. So that denotification itself is bad.
Okay.
Okay. Then, after despite that, MUDA denotifies the land in favor. On one hand, MUDA denotifies the land in favor of Devaraju. On the other hand, on the same parcel of land, MUDA also develops sites, uses that land for formation of the parks and other amenities.
Okay.
So, court says that on one hand, MUDA had acquired the land, and on the other hand, it had denotified the land. On the third hand, the MUDA had gone ahead and formed sites. And in fact, on this parcel of land, it had allotted sites to 19 persons. Sorry. So, there ends the matter. And then, this Siddaramaiah will not be having any power between 1999 and 2004. So, during that period, nothing happens. So, in 2005, in 2004 and 2005, Mr. Siddaramaiah again becomes the Deputy Chief Minister. And at this time, Devaraju, in whose favor the land was denotified, sells this land to one Mr. B.M. Mallikarjuna Swamy. This Mallikarjuna Swami is a brother of Chief Minister's wife, Parvathi. So he purchases this 3 acres, 16 guntas of land on which the MUDA had already found sites, parks, and other amenities on the pretext that these were the agricultural land, and he purchases it from Devaraj. Okay, there ends the matter. Then there was not much development. And in 2010, this Mr. Mallikarjuna Swami gives a gift deed in favor of his sister, that is Parvathi, who is a wife of Chief Minister. This 3 acres, 16 gunta of land was given in the form of gift deed to her. So, during this period, Mr. Siddaramaiah was not a Chief Minister, but he was a leader of opposition at this time. And in 2013, Siddaramaiah comes back and he becomes the Chief Minister. And in 2014, the allegation in the complaint and what has been noted by the court is that Miss Parvathi applies before MUDA saying that, see, this land of mine, which I got through my brother through gift deed, is being used by MUDA illegally and farmed layout. So this is how she writes a letter to MUDA. Then MUDA says, oh, okay, then we will look into it. Then he files another application to MUDA saying that please compensate me for the using this 3 acres and 16 guntas of land illegally, which is now in my possession, which you already farmed layout. So you please grant me alternative land. So MUDA goes through this application and recommends to government that alternative sites in the proportion of 60 and 40 ratio. There was a rule at that time. If government acquires certain piece of land, then 60% of that portion of the land will be utilized by the government, and 40% will be given back to the landowners. That is a developed land. If that developed land is not available in the same layout, that 40% of the developed land will be given in some other similarly situated layout. Then, but what happens after that? Suddenly, the government decides to change the land, that rule, instead of 60-40 ratio, 50-50 ratio. That means government uses the 50% land and the government will return the 50% of developed land in lieu of compensation to the landowners. So government approves and amends this rule to 50-50, and based on that rule, in 2017, MUDA passes a resolution saying that, okay, we will allot the alternative site to Miss Parvathi as a compensation. So after that, there was not much development. Then suddenly, what happens in 2021, MUDA proceeds further and asks Parvathi to surrender her 3 acres, 16 guntas land. Surrender is only on paper because MUDA has already made use of that land for formation of the layout. Sites were formed. She does it on paper. MUDA takes that and then decides to allot 38,200 odd square feet of land in Mysuru in lieu of these 3 acres, 16 guntas. These 38,200 odd square feet land, which totally forms 14 sites, which were given to her in Vijayanagara third stage, which is a upscale area of Mysuru, though this land is situated in 15 kilometers away from Mysuru city, which is land acquired from the originally. So here the allegation is that rules were bent in favor of Chief Minister's wife. What had happened is, in registering these 14 sites, MUDA quotes a rule of 1991 that these sites were given to her as per the 1991 rule. Interestingly, this 1991 rule, she was not allotted the sites under 1991 rule, though it is quoted in the allotment letters. She was actually quoted under rule of 2014-15, which was amended by the government. And soon after this allotment is done to her in 2021 and 22, in 23, suddenly government writes to MUDA and all other authorities saying that this application of this 50-50 rule and 60-40 rules to allot alternative sites as a compensation is wrong, and government withdraws that rule. And thereafter, By the time government withdrew that rule, the sites as per that rule was already allotted to chief minister's wife. And in 2023, the High Court says chief ministers come back to power. That is, Mr. Siddaramaiah come back to power as a chief minister. And his government also says that this application of this 50-50 rule and allotment of alternative site is wrong.
Yeah.
High Court noting all these things says when government itself has admitted that allotment of sites under this 50-50 rule is wrong, and how did MUDA allot sites to her? And what would happen to the sites which is already allotted to her now, even though the rules were withdrawn now? And court
Okay.
says all these developments happened, that is in favor of, that is denotification, and particularly from 2004 when his brother-in-law buys this land and transfer it, gift it to his wife, his brother, I mean his sister, that is chief minister's wife, and she is seeking compensation from MUDA in the form of alternative site, allotment of alternate site, change of rule, all those things. The court says that Mr. Siddaramaiah was holding key posts like chief minister, deputy chief minister, leader of opposition, and
Yeah.
these things have happened, and these rules were bent prima facie. That means to see, for the time being, it shows that it happened to favor the chief minister's wife.
Okay.
It would not have such a bending of rule or illegalities would not have happened if it were to be any ordinary citizen.
Okay. Yeah.
And the court says prima facie. Court says that it is these things has happened prima facie because behind all these things, actually one of the contention of Chief Minister Siddaramaiah is that he had not signed any of the documents related to transaction of these land, whether the government decision or anything. He never held any
Right.
portfolio. He had
Right.
never signed any document related to this. So he says that I was not at all involved. My role is not at all there. But court said that your role may not have seen in the right front in the form of signing or taking a decision. But certainly, court specifically uses the word. Mr. Siddaramaiah definitely was behind the smoke screen, or not just smoke screen. He said certainly he was behind the screen because it is because of all these decision taken by MUDA and all. The ultimate beneficiary is chief minister's wife. Court says if the beneficiary of these decisions of the government is some third persons who are not at all related to chief ministers or his family, things would have been different. But here, since the beneficiary is none other than the chief minister's wife ultimately, so this requires an investigation at least. Court doesn't say that all of these people are guilty. What court says is that to unearth what exactly happened, whether Mr. Siddaramaiah having all these positions as a leader of opposition, as chief minister, as deputy chief minister, whether he has used some, court says, undue influence. That means he has, from behind the scene, he has used his position indirectly. So there is a provision in the PC Act, use of undue influence by the public servants. So
Okay.
court says that an investigation is very essential to know whether chief minister, that is Mr. Siddaramaiah, had indulged in undue influence, which ultimately resulted in allotment of these 14 sites. In fact, the original value of that particular site for which the Mr. Ninga, original owner, had bought was rupees 350 rupees. The
Yeah.
compensation announced by MUDA to Ninga was around 3.5 lakh. But now the lands as compensation allotted to Miss Parvathi is around 56 crore.
Yeah. Yeah.
Court says all these aspects certainly requires an investigation before
Yeah.
coming to a conclusion what exactly happened, who is at fault, who is at guilty, whether there is an illegalities, to what extent is the illegality, whether there is a criminal act on behalf of the chief minister or anybody else. So court says all these aspects requires investigation. This is how the court has gone on law and on facts of the case and allegations.
Okay.
Hope
Right.
I hope I'm able to convince. I mean, what has happened in the court?
Yeah. Yes, sir. Yes. Now, Moving on to the following the verdict, there have been discussions on the power that the governor holds. The High Court said that it found no fault in him exercising independent discretion, like you mentioned. But there have been arguments about whether the governor himself was free from bias, along with criticisms that the BJP government the NDA government is trying to destabilize elected governments through the governor. But in the court, what were the arguments that were in favor of the governor's action that led the High Court to uphold his decision?
Yeah, the High Court's High Court's finding is very straightforward. It says that governor got certain complaint. He referred that to the chief minister. He asked chief ministers. He brought it to notice of chief minister and the government. The court also says that while considering the complaint under Section 17A of the PC Act to grant permission for investigation, governor was not even required to issue notice to the public servant. That is Chief Minister Siddaramaiah in this case. Still, government has chosen to give a notice to him, though he was not required to give a notice in law. He has chosen to give notice in his discretion and considered them and found them not reliable, because the reply given to him is not convincible. He says, court says that governor has applied his mind. He has gone as per the law laid down by the Supreme Court as far as the whether to consider cabinet decision or the chief minister's reply. He has gone to that. He has gone through the chief minister's reply very well, and he says that the government says, the court says that the governor's action is certainly not of any biased kind of thing. He's purely gone based on the records.
Okay.
This is how the court has viewed, and court has found no fault with the governor's action.
All right. Okay. Now, based on the special court's order, an FIR has been registered against Chief Minister Siddaramaiah, his wife, and two others.
Yes.
And this is trying to investigate a private complaint that was filed by activist Snehamayi Krishna in Mysuru. And he was one among the social activists that approached the governor, one of the three. So can you tell us what this particular complaint is about? I mean, all of them, one way or the other, tie into the MUDA case, but what is this particular complaint about?
It's exactly the same what I had explained till now about how the High Court has considered the facts of the case and allegation. How I explained from what happened from 1992 to 2023, and from notification of that particular land, which was not with the chief minister's family, but they purchased it in 2004, and then how it went about. So this complainant, Mr. Snehamayi Krishna, narrates all these details in his complaint and says that all these things are happened, and a public land which is worth several crores rupees. Now current market value is about 56 crore rupees, and in fact Mr. Siddaramaiah himself has in a public statement had said that he is prepared to go by these give up this 14 sites if MUDA offers him a compensation of 62 crores, which is current market value.
Okay.
Court has considered it as only 56 crore the market value present. So complaint of Snehamayi Krishna was that a public land for which chief minister's wife not eligible to to claim such a vast size of public land as a compensation, the government and MUDA had given such a vast land in the heart of city to her, and it is nothing but misuse of power by chief ministers and assisted by certain government servants like IAS officers who served in Mysuru and MUDA. And for this, it's an attempt to take over the government land in an illegal way. Showing that it's a compensation for some land which was acquired. So he had moved the special court in Bengaluru, seeking an order from the special court to order an investigation through an independent agency or Lokayukta police like that. Actually, special court had heard argument on this and had kept its order pending. While pointing out, see, as per the High Court's direction, special court cannot, even if finds that there is a case for ordering investigation, special court cannot order such investigation without the approval by the competent authority. In this case, competent authority was a governor because the allegations were against chief minister. So court said, the special court said that no, I cannot pass an order because I cannot entertain the complaint in the absence of sanction. At that stage, Mr. Snehemai Krishna and two others, private individuals, had gone before the governor seeking sanction, approval for investigation under Section 78 of the PC Act. So governor acted on that and granted sanction. So it is now, what happened is 2 days back, High Court, High Court, when it entertained Mr. Siddaramaiah's petition against the governor's sanction for, approval for investigation, had asked the trial court, special court, to halt its proceedings till High Court decides the chief minister's challenge to the governor's permission. So when High Court dismissed on September 24, High Court dismissed chief minister's petition, it gave a liberty to the special court to go ahead with this complaint filed by Snehemai Krishna and others. So special court went ahead with its procedure, and day before yesterday, that is on 25th of September, a special court directed the Lokayukta police, Mysuru, as you said in the beginning, Lokayukta police to register an FIR under several provisions of the law, like Indian Penal Code, prohibition of Benami Properties Act, and prohibition of Land Grabbing Act, and etc. And of course, the Prevention of Corruption Act against chief ministers, his wife, and his brother-in-law Mallikarjuna Swamy, and person who sold land to Mr. Mallikarjuna Swamy, that is Devaraj. So these four people, the special court has passed this order.
Okay. So in light of all these developments, Siddaramaiah has repeatedly declared that he is not afraid of facing an investigation, and he has categorically declined from resigning from the CM's post. He has pointed out that he's also pointed out that the court order pertains only to investigation and not prosecution against him, and has spoken about consulting with legal experts. So at this stage, what are the legal options available to him, and which aspect of the High Court's current ruling do you think he's likely to appeal against?
See, obviously, he has to appeal against the High Court's judgment, which has gone against him, which has dismissed his, not only dismissed his petition, High Court has very specifically said that this allegations made against Mr. Siddaramaiah in the complaints by 3 people definitely requires an investigation. So when High Court's single judge bench, Justice M. Nagaprasanna, had very clearly said that the allegations against the Chief Minister undoubtedly requires an investigation, at least to know what exactly has happened, what is the extent of illegalities and criminal aspects of those allegations. So now, naturally, Siddaramaiah's advocate, soon after High Court pronounced its verdict, sought a stay of that order to appeal against that judgment. But High Court said no. So following that, special court has gone ahead and directed for registration FIR. And today, obviously, the Lokayukta police have registered FIR. Now, the option before Siddaramaiah is 2. One is to file an appeal before a division bench of the High Court, or directly approach the Supreme Court. So, which action that because meanwhile, a new development is that in addition to this dismissal of his petition, now FIR has already been registered. Now, he has to even challenge that FIR. Along with any appeal that he files against this single judge's order of September 24, whether it is before the division bench of the High Court or whether it is the Supreme Court, probably he will have to go by what his legal advisors say. There are two opinions. Some legal experts say that he can move before division bench. But some say no, he cannot move before division bench. He has to go before a Supreme Court directly. because
Okay.
it is an order passed by a judge which is related to the cases related to special court. So when the High Court passes an order on cases related to special court, in the special court on MP MLAs, naturally the appeal on such cases will lie to Supreme Court directly, not to division bench. But it is a debatable legal issues which probably will be, fought either before the division bench of the High Court or before the Supreme Court before anything further happens.
Yeah. Okay. And we'll have to see how this pans out in the near future.
It is certain that it is a very long, long-lasting legal battle. It's only begun now. It will go
Beginning. Yeah.
different forum, different time. It will take its own time.
Okay. All right. Thank you, sir. Thank you for joining us. Just to wrap up, the Lokayukta is set to begin its investigation on the complaint of corruption, and the CM, like you said, is staring at a long legal battle ahead of him. But most importantly, while this is happening, the BJP has also challenged the CM to prove his popularity by seeking a fresh mandate. So, all eyes are now on the future moves, both legal and political, that CM Siddaramaiah himself, as well as the Congress party, is likely to take. And we'll be following all the developments and bringing them to you. Thank you for joining us today. For more such stories, videos, and any related developments, follow the Hindu.